where we're at. We're going to be analyzing some concepts that really sometimes clash with legal issues and conflict issues and ethical issues. And hopefully what we're going to do is boil them all up to the top and then make suggestions, and only suggestions, as to how to live with this arena. Now, preparing clients for their involvement in the legal and mental health connection is extremely difficult. It's been extremely difficult for lawyers. I know there are some areas when you're talking about preparation, whether it be a consultant or a lawyer, you're faced with, I think, some of the biggest troubling ethical concerns that you have. And sometimes they're just minor nuances that lead into huge issues. When we're talking about a lawyer, for example, we all know that we've been able to prepare clients. We can suggest them how to be a witness, suggest to them how to testify, but we can't suggest what to testify. We can suggest and describe and educate what the court process is. We can prepare them for cross-examination, but we can't, again, cross that line into suggesting how to testify. We can't suborn perjury. What we say and how we structure it, whether you are the consultant that is brought in, I'm the lawyer and I brought you in and I've said, you know, I can prepare as much for this client as possible, but you're going to have to, as I'm showing them how to live in the house of the law, you're going to have to show them how to live in the house of psychology that is going to walk into the law. And there we go with some of the difficulties. Today what we're going to do is we're going to have, hopefully we're going to hone in on some definitions of what is coaching and are there negative and positive connotations of coaching versus consultation, and are there negatives and positives about that. The ethical and legal maze that can get foggy and then can all of a sudden make you hit the freighter that you didn't see in the fog. And we have some tremendous professionals who have really, once again, devoted a ton of time to these issues that are going to help you today. I'm going to introduce them individually before they give their little 10-minute overview of what's important to them. And then we are going to, as we've done in the other plenaries, follow through a few scenarios, real-life scenarios, and then get everybody's comments. Once again, questions from the floor, please submit them in writing. We've got Leslie Hunter is here. She's going to go around, and I thought that Linda Fieldstone was, oh, there she is. She's also going to help pick up your questions. So the first speaker that I want to introduce is Dr. Renée Lair. She is both a lawyer and a licensed psychologist. Boy, talk about living at the intersection of law and mental health. She's got with clinical and forensic psychology practice in Santa Monica, California for 20 years, and her work is focused on helping parents, children, and families during high-conflict divorce. In addition to her clinical practice, Dr. Lair also serves as a mental health referee for the Los Angeles Superior Court. Dr. Lair.
Well, I'm very pleased to be here today, and I'm especially pleased that I've had help with technological difficulties. Let's see. There we go. We'll be talking about various ways that mental health professionals will be consulting on litigated cases, custody cases, at various points during the case, kind of from the beginning to the end. And one of the things that I want to focus on in my opening here is an area of consultation that has been very controversial, and that is mental health consultation with one parent to help them prepare for a child custody evaluation. Now, there won't be time to go through all of this. I have spent a considerable amount of time working out what I believe is a good model. It's a 6-step model for conducting an ethical consultation that does help a parent during a custody evaluation. A lot of the controversy about these consultations has come about because they're perceived as somehow manipulating the evaluation process. You know, where that maybe that wolf in sheep's clothing is in the title of our program today. We're seen as coming in and trying to help this parent fool the evaluator. And somehow interfering not only with the evaluation process, but perhaps even with important fact-finding or decision-making functions of the court. Adding to the perception that we're doing some kind of behind-the-scenes manipulation or cover-up for this parent is the fact that they're frequently conducted in secret. And some of the parents are even instructed by their attorneys not to tell the evaluator that they have had a consultation with a mental health professional or any help from a mental health professional to prepare for the evaluation. An additional factor in leading to the controversy is that there aren't any guidelines or standards of practice regarding these consultations. So while one of you as a mental health professional might be conducting a very ethical consultation, someone else may be doing things that are completely unethical, may be doing what we call, or going to be calling, coaching, that is feeding answers, covering up, kind of reinventing history. One of the additional reasons, I think, for the perception that these consultations are unethical cover-ups is what I call the clash of paradigms. That is that the legal profession and the mental health profession have a different method of problem solving. Having been both an attorney and a mental health professional, I know something about both worlds. And the legal approach to problem solving during litigation is to cover up. You want to make your client look all scrubbed up and clean and good. You want to make them look as good as possible when they go into court or before the evaluators in hopes that the judge is going to find in your client's favor. But the mental health approach to problem solving is different than that. It's the opposite of cover-up. What we like to do is get all the problems out on the table. We want to take a good look at them, and we want to find some solutions for them. You know, what are the problems here, and what can we do to make it better? But when we're hired as a mental health professional, when we're hired by an attorney, the assumption is that now we've crossed over and we're going to be covering up. We're going to be trying to scrub up this parent and make them look good for the evaluation. Now, experienced family law attorneys, they know that at their heart, a custody case, especially an evaluation case, but custody cases are different from other kinds of litigation. They're not about who's going to win and who's going to lose. They're really about what are the problems in this family and what has to be done to help to resolve some of these problems. That's what the evaluator is going to be doing, taking a good hard look at what the problems are and what can we do to find some solutions, make some good recommendations that are going to help this family function better and hopefully have the outcome of a happier, healthier child. So the evaluator is going to be wanting to find the problems. They're going to be looking for the warts. So the experienced family law attorney knows that you don't want to try and do a cover-up. What you want to do is work with a mental health professional to try and see what the warts or the problems are and then do something about them. Hiding and minimization of a parent's problems can backfire and harm the client's case. So An attorney most effectively and beneficially advocates for their client or parent by working with a mental health professional consultant to help motivate the parent to improve. So ethical consultations then are not about hiding or cover up. They're about trying to make this parent be the most improved, best parent and co-parent that they can be, and that is in the best interest of the child. If you have a better parent and co-parent, that's in the best interest of the child. Now, the 6-step model, I'm not going to have time to go through it in detail. That's a whole presentation in itself. But in brief, the first step is assessment and triage. In assessment, step 1, you're getting a lot of information. You've been retained by the attorney, and the attorney is your client. You've become their consultant, and you're getting information from the attorney, from declarations, and from interviews with the parent. And you want to be sure that when you get this information and during these interviews, you're avoiding what I call a bunker mentality, kind of an us against them. You want to remain open to both sides of the conflict. You want to get a good, clear picture of what this parent is saying, but also what this other parent is saying about this parent's problems. So you're not going to be listening for how bad that other parent is and how are we going to beat them. Instead, you're going to be listening for how good or bad this parent is doing individually and as a parent and a co-parent. You're going to assess what they have to do to improve, and you're going to right away make some suggestions to them for positive change. Now, usually parents don't like to hear that I have a problem. It's the other parent who has a problem. However, when you come in as a consultant, they see you as being on, quote, their side. And you are on their side, just not in the way they think you are. You are going to try and improve things and help them get through with some good outcome, just not in the way that they think you are. But they are very open because they perceive you as being on their side. They're very open to suggestions you want to make. I mean, you can say things to them that if you said to them in another context, they would be very defensive about, very unwilling to hear. So you're in a good position to say, hey, you've got some problems here, and here's what I think you need to do right away. Now, step 2 is to educate the parent, and a lot of the consultation really is about education. You want to help that parent understand and acknowledge how their problem behaviors that you see are impacting their child, the other parent, and continuing to contribute to conflict. And you want to help them slowly as you do this reframe their perspective and become more child-focused. Not so focused on, oh, that other parent is a problem, but more child-focused. So you want to let them know also that you need to do this, mom or dad, because this is what the evaluator is going to be doing. This is about the best interest of your child. That's the standard for the evaluator and for the judge in the case. So you need to be looking at this in this way, and it's our job as the consultant to try and make sure they understand it and they get it, because that's what the evaluator is going to be doing. The big question for the evaluator is going to be, does this parent get it? So they need to take serious steps to remedy their problems. Cosmetic stuff that comes along with, quote, coaching kinds of work is not going to fool the evaluator. Nothing is going to replace their hard work on what their issues or problems are. And the attorney and mental health professional can really work together as a team to help motivate that parent to improve. Step 3 is education about the process, educating about the evaluation process. I would never want to go through it. I'm an experienced professional, but I still would not want to go through it. It's a very frightening process for even very good parents. It's scary. They don't know. There's a lot on the line, and they do not know what to expect, really. So educating them about the process helps them understand and get comfortable with it. Knowing what to expect is going to help reduce their stress and anxiety, and that reduction in stress and anxiety can, in turn, just in itself, that reduction of stress can help them improve their parenting and co-parenting. And they begin to understand that they have some control over what's going to happen to them by addressing their own problems. Step 4 is we would work on custody requests. You know, they have to, in this parenting plan that they're proposing or requesting, their requests have to be realistic. You know, we want to help them think through what it is that they want, what do they think is going to be in the best interest of their children, and then how does that square with what we know about, you know, what's good for, you know, 2 or 3-year-olds or 9 or 10-year-olds and so on. We want to help them begin to think this through. And then we want to also help them think about what changes they're going to have to make to achieve what it is they're asking for. What changes do you have to make? Step 5 is issues and concerns. We all know that that's a big part of the evaluation process. So we're helping them to all of the consultations, helping them to begin to think, you know, reframing what's going on in their family in a different way than they have been. So their issues and concerns about the other parent, they're going to be talking about that with the evaluator, and we want to help them think through, what is it that you're really concerned about here? You know, sometimes they come in and they're bringing in all the detail for everything but the you-know-what. The kitchen sink is brought in, and we want to help them kind of sort through what are you really concerned about here with that other parent. Then we want to help them distinguish what's important, what's not. How realistic are their concerns? You know, I'm afraid if Dad has overnights with her, you know, he's going to abscond and disappear to another state. Well, is that realistic? Is it not realistic? You know, how realistic are the concerns? You help them think that through. Then you want to make sure that they have support for their concerns. Are there some real reasons for these concerns, or is it just, you know, something off the top of your head here, or based on something that happened one time and isn't really a pattern? What support do you have? What are the examples? And then, very importantly, do their concerns logically relate to what their custody requests are? There should be a logical nexus between their concerns about the other parent and then what the requests are. So we're helping, now we as evaluators, sure, we know this, but they don't, and we're helping them to think about this. And all of the concerns have to be they should be child-focused and not focused on anger at the other parent. You know, if they come in really angry, and most of these parents are pretty angry, and most of them have some reason to be, but we know that if they go in really angry, presenting that in a very angry fashion to the evaluator, that the evaluator may just tune out. You know, may just think, well, this is a very angry parent. And even if some of their concerns or issues are realistic and reasonably related to behaviors in that other parent, you know, we may just write them off and say, this is an angry parent. All during this process, starting with the assessment and going down to the educational steps about the process and so on, you will see that these parents who come in very angry, that as they start to shift their thinking and refocus, reframe, that a lot of this begins to melt away. You begin to see a much less angry parent, but it's a natural part of the process rather than us saying to them, hey, don't go in angry like that. Don't say it that way or you'll be executed. We want to make it a natural part of the process so that it becomes meaningful and is a real part of some kind of change in them, improvement in them. Step 6 is psychological testing, and we're going to be talking about that on the panel. I think we have something coming up about that. So I'm going to reserve my thoughts about psychological testing and how that enters into one of these consultations until then. Thank you.
Some of the phraseology is very helpful, but still some of the phraseology, when you think about it, is still difficult. I think one of the phrases that I wrote down that Dr. Lair indicated was, what you want to do is reframe their perspective to become more child-focused, to be able to communicate with that important reframing. And when that gets to a potential point of, you don't want to say it this way because you'll be executed, that's where you're in that danger zone, and you can always walk towards that danger zone. I'm going to call on the legal perspective at this point, because I hope we can deal with issues such as when the consultant, first of all, when you bring in a consultant to assist you, when you do that, are you retaining them? When you retain them, are they part of your work product, or what we call protected by litigation privilege? So these are all legal type issues, along with the ethical concerns of how do you merge this appropriate preparation with some ethical no-nos. And what I'm going to call on Diana Gold-Saltman, and she is a principal in the Los Angeles law firm of Gold-Saltman Law Offices. She's specializing in mediation and litigation of family law issues. She's certified as a specialist by the State Bar of California and the Board of Legal Specialization. She is a fellow of the American and International Academies of Matrimonial Lawyers. Ms. Gold-Saltman got her BA in psychology from the University of California, Irvine, and her Juris Doctorate from Southwestern University School of Law.
My job is to simplify. My job is to take things that sound complex and make them understandable both to my client and to my judge. So in assessing whether or not I'm going to use a consultant, that's a determination that as an attorney you need to make early on. It may be that early on you will make the decision that you're going to hire a consultant not at the first stage. Frequently it's a good idea to do so if you're going to have a consultant involved to have them in at the first stage, but the decision is what needs to be made at the first stage. And frankly, sometimes it's just good to have a consultant to share the commiseration. So you have somebody who, when the client's doing something you can't imagine is in the client's best interest, you have someone you can call and say, you'll never believe what our client has done. So there's a certain cathartic mental health aspect for the attorney that makes the consultant role very helpful. It's the attorney's job to know the limits of both legal and psychological professional ethics, because ultimately it is our job as attorneys to make sure that neither line is crossed. We don't want to do anything that, as John indicates, starts looking like we're attempting to pull a fast one on the tribunal by doing things that, even if they are short of actually suborning perjury, do something to make our client look like a different person before an evaluator whose thoughts and words are going to be presented by way of testimony or other evidence to a court. We need to make sure that our process remains clean. But in doing that, we also need to understand the ethical limitations of the mental health consultant role, because we don't want to ask you to do something that is inappropriate. And frankly, it's our job to know what is and isn't inappropriate. Our interpretations of that may differ from yours because our perspective is different from that of a mental health professional. So sometimes you'll need to let us know what those limits are so that we aren't inadvertently asking you to cross lines that you can't cross ethically. When we use consultants, mental health consultants, the consultant becomes part of the team. And I've listened to a few of the programs over this weekend with regard to consultants, of which we seem to have had quite the plethora, as my son would say. And I've heard things that I think conflict with each other. I've heard people talking about ways in which consultants are used that focus on the best interest of the child, and I've heard other people say it's inconsistent with the obligation of a consultant for an attorney who represents one party or another to attempt to purport to be neutral and address in an objective way the best interests of a child. Ultimately, as a consultant, you make a determination as to whether or not you wish to be part of a team. And obviously, the team has a goal. The attorney is the client. I don't think I can stress that more thoroughly. The attorney is the client of the consultant. And why would that be? In part because it's the dyad between the consultant and the attorney that's going to forward the process. The attorney leads the team in the process. Most attorneys are bound by their professional ethics. In the United States, about 48 states' rules of legal professional ethics are based on the American Bar Association model rules. One of those rules is that the client determines the objective of the litigation. The attorney determines the process by which that goal is accomplished. The attorney has the job of advising the client as well. So if the objective of the litigation isn't appropriate, it's the attorney's obligation to advise the client that the objective is inappropriate, illegal, it needs to be, that the data, the facts don't match up with that goal, and perhaps the goal needs to be modified. But at the end of the day, the attorney's ability to direct the goal is limited to the consulting, the advising portion, the counseling, if you will, of the counselor at law role. If the objective is something that the attorney cannot tolerate and cannot zealously advocate, because in his or her mind this requires not a breach of ethics, because ethics is a code of agreed upon conduct, but even morals. If I cannot zealously advocate for you because your goal is so anathema to what I believe I can do for you and sleep nights, then it's the obligation of the attorney not to put forth a different goal, but to withdraw from the representation. And so once the goal is established, if you are the consultant of the attorney and the goal is established, your choice as a consultant is to either say, I'm willing to limit my role to assist you in advising the client to restructure that objective because I find that I think the objective is going to be a problem, and this is where that perception of best interest might come in, or to say, I'm out of here. You're asking me to participate in a process for a goal that I can't abide. And in that case, then I'm just not the consultant for you. There are plenty of others from which to choose, and I think that is what you should do. So it isn't to determine the best interest of the child. It may be to look at the facts objectively on behalf of the attorney-client and that attorney-client, litigant-client, and say, gee, here are some facts that support that the request that your client wants about custody would in fact be in the best interest of the client. And there are ways that we can shore that up and make that shine so that those facts are very clear to a trier of fact. There also may be ways in which your client can do certain things to beef up the position that your client takes so that the goal, the objective that your client states is appropriate, such as there are parenting programs here. Your client seems, by your description, not to quite understand the difference between infants and toddlers. And now that the child's a little older, perhaps some education about toddler needs would be helpful. And then your client's objectives might be appropriate. So that would be a fair role to take. And as with attorneys, consultants also have sort of this binary role, this dual role, if you will. On the one hand, it's to objectively assess the situation. If you are my consultant, you're useless to me if you are a yes man or a yes woman. I'm not looking for somebody to tell my client, oh, poor baby, you've been treated so badly, any more than I would want a therapist for that purpose. I need somebody to take a look at the facts, on both sides, as Renee was pointing out, and to let me know the strengths and weaknesses of my client's position. I want a consultant to advise me regarding a course of action given the existing situation. And of course, in the presentation, especially early on in the case, not all the facts are all that clear, and sometimes the facts are quite different. My client says it happened this way, the other side says it happened this way. We aren't truth determiners. We don't know who's telling the truth. In a therapeutic situation, one might say you take the client as you find them. That's their reality, work within their reality. But for purposes of acting as a consultant for an attorney who needs to present information to a trier of fact in order to persuade, in order to advocate, you need to assess my situation from all angles for me. And from the attorney perspective, because we are advocates, we also have, and this is my least favorite word in the world, to make a paradigm shift in order to determine what we need to do for our clients. As advocates, I think we are trained to fight for our cause, to fight for our client. If somebody says your client's a bad guy, you say, oh no, and let me tell you why. And this is the point at which time you need to not do that. You need to be able to listen. We're often quite talkers, as you may know. And this is the point in time where if the consultant tells me your guy's a schmuck, and here's how you have to do things to make your guy not a schmuck, I need to step back, be able to hear that, and accept the advice, good and bad. On the other hand, I'm not a lemming. I'm somebody who has information. I've hired a consultant because a consultant has a certain expertise that I don't have. Just as judges appoint child custody evaluators because there has been a threshold met in a case that says there's something about this family that the best judge in the world can't know just from hearing evidence. If you can put a laundry list of people on the witness stand and I still won't be able to understand the dynamic of what's going on in this family, so I must appoint somebody who has special expertise I don't, somebody with psychological expertise. The attorney is going to be using the consultant for that expertise, but that expertise is a single component because, as many of you know, child custody cases generally don't exist in a vacuum. And so we've got to use our knowledge of the law and the other aspects of the case. There'll be financial aspects of the case. There'll be logistical aspects of the case. There'll be time aspects of the case. There'll be court docket congestion aspects of the case that we're going to integrate with the information that our consultants provide us. So I want to be able to have the information from my consultant, and I don't want my consultant to get their nose out of joint if I say, I accept some of what you've told me, but I can't do everything you're asking. For whatever reason, financial reasons, time congestion reasons, I need to be able to do my own analysis. Consultants aren't just for litigation. And while primarily the purpose of a mental health professional as a consultant is for litigation, one of the key uses of a consultant, in addition to providing education about both the process and parenting and information they're going to know to carry on well beyond the litigation, is clear. Sometimes the reason I want a consultant is to tell me whether I should not be litigating this case, whether there's a different means of dispute resolution that is more appropriate under these circumstances. I may need somebody to tell me when it's time to hold them or fold them. That may be the best and highest use of a consultant in my case. Ultimately, it's the attorney's job to protect the process. And by that I mean that if I'm hiring a consultant, the consultant is my expert. That allows the consultant to remain part of my work product privilege. Now, what does that mean? What that means is, just as I may use people in my office, we hold a certain confidentiality. They are an extension of me. My expert is an extension of me. If I'm going to have my expert testify, I have then crossed the line. I've exposed them, because I'm going to have them testify, to discovery. Information that they have been provided, the source of the information that they have been provided is all going to be exposed because it's subject to cross-examination. They're going to provide an opinion. We don't live in a star chamber universe, so they are subject to cross-examine based on the basis of their opinion. My non-testifying consultant is in a different position. My non-testifying consultant is essentially my alter ego. However, I can screw up because my work product consultant is only as good as I maintain my own privilege. So attorneys have to know not to inadvertently breach that privilege. When I do, I've exposed my consultant. My consultant could end up being deposed. My consultant could end up being in a precarious position because of my own actions. And how might I do this? I could accidentally name my consultant in my billing statement to my client, which is then subject to discovery on the attorney fee issue. I might accidentally have my consultant, I might stupidly or inappropriately have my non-testifying consultants speak to people who are then going to be discoverable. A therapist, an evaluator, a testifying expert, in which case they become the source is discoverable, and they may become discoverable. So it's the attorney's job to make sure that you're protecting your boy.
Man.
My man. My man. And then finally, and briefly, from the attorney perspective, should you have the consultant deal directly with the litigant? There are benefits and risks to that. And the two most significant benefits to having a client work directly with a litigant is you avoid the game of telephone. If I'm dealing with a consultant directly, I am inadvertently, no matter how neutral I think I'm being, I'm going to be giving my own spin that's going to be information provided through the prism of my perception. I can provide neutral information. I can provide declarations and pleadings. But if I'm the one that's going to be interfacing with a consultant, they're going to get my rose-colored view, no matter how neutral I'm attempting to be. It also may be a more effective way, by having the consultant deal directly with the litigant, to work with the litigant, especially in the education process. The risk, of course, is that there's going to be a breach of the work product privilege, which is what you're so trying to protect, and also a significant blurring of role boundaries, because at some point, if I'm having my consultants work directly with my litigant client, I may be blurring the lines between education and therapy.
Back to the blurring of the lines. Sometimes it's extremely difficult. There's the legal ethic is that lawyers have a duty to their client. They have a duty to their client to advance zealously their case as long as it's within their ethical boundaries. They're also having a duty to the court as an officer of the court, and they can't allow evidence to go before the court that is misleading. And then you question how, if this witness is shaped, are they shaped to the point that the evidence becomes misleading? And to answer some of those questions, we now go back to the profession of the psychologist. I'm calling on Dr. Kirkpatrick, who I have to say at the outset has the absolute best accent of any of the panel members up here. And Dr. Kirkpatrick is a clinical forensic psychologist in private practice in Charlotte, North Carolina. And he also holds a diploma in forensic psychology from the American Board of Professional Psychology. He is also a principal in the consulting group of child custody consultants. Dr. Kirkpatrick.
Thank you. The notion that a Canadian could tell me I have the best accent is just unbelievable. I want to make a connection to John starting off by the anatomy of a murder illustration. Several years ago, I was meeting with a public defender who represents death penalty cases. And I never worked with her. We met for breakfast to talk about possibly my being retained on a case. And in the course of the conversation, I learned that she used to be a family law attorney. And I said, how in the world did you go from family law to the public defender's office representing murder cases? And she said, it's very simple. Representing murder cases is a whole lot easier because the murder has already happened. All right, so what's the point? Well, this is a very, very high-stress profession. I've actually had a conversion in the past couple of days. Besides the fact that I'm dressed up, I'm actually a changed person. Because a lot of my practice is providing court-appointed custody evaluations, but also being hired as a consultant to critique the custody evaluations of colleagues. And it has not engendered a lot of friendship sometimes. It's very, very difficult to offer criticism about colleagues because we mental health folks take it personally. It's not meant personally. But if I tell a colleague, you know, I think that's about the worst custody evaluation I've ever seen. It doesn't go over well. So what's my conversion? Well, I'd like to figure out a role for myself in my golden years that is a little less stressful. It would be nice to not have to always evaluate high conflict custody cases where people really would like to kill each other. They would like to scorch the earth around the other person's house. They would like to obliterate the other person. They might think about the child after the obliteration. So I came here to the conference thinking, how in the world could anybody do consultation ethically, morally, that sounds like coaching? And so I've been going to these workshops for the past couple of days and listening to some pretty bright people whose opinions I admire, convinced me that there may be some way to consult in an ethical manner. And so I've had a bit of a conversion. Now, you didn't see it, but I'm just testifying that it happened. Thank you. Can I get a witness? So,
You got a witness. I was fearful before your conversion.
Yeah, I was going to go after Renee.
I was scared.
I also was afraid nobody would show up for the plenary session, so thank you for being here. I want to make 10 points that have proceeded from my conversion. One of the things that I have always done and will continue to do as a consultant is to make sure that my role is very, very clear. And the way I have done that and was trained as a forensic psychologist is write a very clear, cogent letter of understanding back to the attorney after the phone call that memorializes the conversation. And I say at the bottom of that, this is my understanding. If I misunderstood something, get back to me. Okay? That's very important. My wife is a family law attorney, and she and I often say to each other, there ain't nothing like a good paper trail.
How romantic.
How romantic. We'll talk about other things. I want to make sure, point number 2, that my role is congruent with the expectations of the attorney and the attorney's client. I've heard several of my colleagues this week talk about the litigant as their client, having said just earlier in the conversation that really my client is the attorney. So I think we have to be careful, because the litigant is not my client. I'm working for the attorney. I'm getting paid by the attorney. My contract for services is with the attorney. And there's some attorneys I don't like to work for. And so if I can become congruent with the expectations of the attorney, I can perhaps do the consultation. I want to make sure that my services contract is very, very clear. And I want to have a very good understanding about the privilege issues. I don't want to be outed accidentally. I don't want to have to suddenly be exposed and expected to testify. But it happens. It may be a mistake, but I want to try to protect myself about that. So I say about 50 times, I am not going to testify. I am not going to testify. And I say that again. Now, I've played a lot of sports in my life, and I've worked under a lot of coaches. And coaches and coaching means to me as a male that the guy is going to tell me what to do. The guy is going to improve my skills. The guy is going to let me go in the game or out of the game. The guy's going to chew my head off if I make a bonehead play. I am not going to coach the litigant. I'm not going to testify for the attorney. I'm not going to coach for the litigant. I'm not going to taint the evaluation process. If there's a custody evaluation on the horizon, I'm good with trying to actually keep that from happening, because I think custody evaluations, especially the ones I do, high conflict, just short of murder, kind of massive revenge-driven, spend all the money possible cases, I think they're a bad idea. So if I can somehow find a consulting role that'll bring the temperature down, I'm good with that. I want to conduct myself ethically at all times. So that's always my guiding principle. It's kind of, where is my ethical compass? How's it looking as we go through this process? I want to be paying attention to that, always. The American Psychological Association wrote some guidelines for conducting child custody evaluations. Now, I've been critical of the fact that they're guidelines. You know, that seen in Pirates of the Caribbean where, well, there's, they're not really standards, they're just guidelines. Talking about the pirate code. We have standards for conducting ourselves. I believe very strongly in that. But the American Psychological Association, I don't know who to give credit to about this because it was a document by committee, but the adjective psychological is put on the front of best interest. That's what that document is all about. It is how to conduct evaluations in the psychological best interests of the child. Now, why is that important? Well, because I don't know what best interests are. In fact, most courts haven't a clue. This country has not come to a consensus definition of best interests. It's not my job. I don't want to pay attention to the finances. I don't really want to know what the forensic accountant figured out about all the offshore accounts. But I can bring expertise as a consultant within the realm of the psychological best interests of the child. If there's anything I know, that's it. And then I'll have to worry about stepping outside into the other best interests, because that's the attorney's job, that's the trier of fact's job. So it helps me keep my anxiety down because I know what my turf is. And I'm not going to treat the crazy litigant. I'm not going to provide therapy at all. So, in summary, I would say that I think the idea of a consultant is a fine notion. I'm beginning to see how it could be expanded. Back at the beginning of the case, I'd love to have a call from an attorney at the beginning before everybody's decided that let's go to war. I think that would be fun. I think I'd sleep better at night. I wouldn't obsess over all these lengthy reports. So I'm grateful for what I've learned from a lot of people this week. Thank you.
Thank you very much, Doctor. Thank you. All right, now what we're going to do is there's a number of scenarios we're going to put up. Everybody can read them as we go. Hand in the questions to either Leslie or Linda. They'll be floating around and we'll integrate them. But here's some real life situations that many of us deal with. And you'll see, once again, that the phrases that we apply seem to be understandable, but they become fogged as we go along. Is this role starting to become a therapist versus a consultant, and can you mix the two? Here's the example number one is Henry and Jane separate and enter into joint custody, week about residence for the two children. Both girls, 12 and 8. 6 months later, Henry and Mary start a serious dating relationship. And Henry tells his lawyer that he and Mary, they need help. They need someone who can assist them in dealing with the children's upset over their mother's anger about Henry and Mary's relationship. They also feel that the children need help in dealing with their mother because of the issues she has with that relationship. Do you have a role here? The lawyer calls you up and is really trying to get you involved in a helping way. Does that come under the rubric of consultant? Let's just continue to go with you, Dee.
Oh, why me?
Because you were on a roll when I got up.
With my newfound insights and wisdom, such as they are, I would consider addressing with the attorney, probably with the attorney and I in the room together with the litigant, what the research might suggest about ways of helping the children in divorce circumstances, especially the whole question about introducing new romantic partners. I think I could do that all right. I would not get in the role of helping the children. I would help the attorney and the litigant find a good child therapist.
All right, Diana, could you comment, because if Dee did contact you to a certain extent, I don't think you're now hiring him as part of your litigation team, and so that the discussions that may have taken place at this time were not for the purposes of litigation. So tell us where that stands legally and ethically.
Well, I agree. There is, although there isn't specifically litigation, I can still engage him for two things. One is as a peer consultant. I'm not asking him to provide therapeutic services. What I would probably want to do is have him on board as my consultant to say, gee, from an attorney perspective, I sort of know, as I'm looking at this scenario, that there's something going on that might require some kind of conjoint therapy. But I'm not really sure what kind of configuration that would involve. And as I'm looking at the two parts of this issue, the children's purported problems and the problems I'm dealing with the children's anger at my new significant other, my client's new significant other, I probably want to say, gee, what kind of therapy is that for? Could the same person do that? Who in town does this work? Are there people that I should avoid? So that kind of using him as a peer consultant for that purpose would both allow me to get the appropriate referrals and would also allow me to retain him if I'm seeing down the line that there's the potential for litigation to continue to work with me without having crossed a role boundary.
Rennie, do you think, Rennie, that this first phone call is dragging you into potential multiple roles? And where would you draw the line? All right, well, now the conflict has escalated as you see the new problem advances, and there's a custody application that was filed by Jane. Remember, Jane's still the wife. The divorce application hasn't happened. The court refuses to change the joint custody regime at the interim stage and orders an evaluation. The evaluation starts, and Henry and Mary go to Henry's lawyer to complain about their discomfort with the evaluator and concern about their lack of preparation for the evaluation process. Can't you get me somebody that's going to help me be able to talk in this living room? And we'll start right back at you, Rennie. And what appears to be met both by the lawyer and the potential consultant, and this is a question that come in from the floor, is that the litigant is defining the problem and as the mother's and children's problem without willingness to look at the advisability and the impact of introducing the children to the significant other and how to do that properly. So as you see multiple perspectives coming in, if you're hired as the consultant, are you hired as the consultant to broaden the perspective on which the client is looking? You say the client is the lawyer. Are you saying that, boy, this looks pretty one-sided here, and I don't think I'm not going to be able to help you if I can't assist in showing to you that we need to see more than the one-sided perspective of what the definition of the problem is. Diana, what do you do with that?
Well, I agree that part of the consulting role of the consultant with the attorney is to broaden the perspective. But I also see that as sort of closing the barn door after the horse has escaped, because if Mary and Henry have come to me as a couple, I can't unintroduce her to the kids. So we do, to some extent, have to take the parties where we find them. One of the things that this scenario caused me some concern about, and maybe something I would want to privately talk to the consultant about, is purportedly I only have one client. My client is Henry. Mary is sort of a collateral quasi-client under these circumstances. And what if Henry and Mary break up? And is she going to be Jane's first and best witness? So I'm going to have a little concern. Yeah, that would never happen. So I'm going to have a little concern about the extent to which the information provided to me by my consultant will assist Henry whether or not there's a Mary, under Mary's present circumstance vis-a-vis Henry's family, so that I can apprise my client, who may slap me upside the head to say, what do you mean Mary's the love of my life? But my job is to be, to some extent, an agent of reality and have my consultant assist me in being that agent of reality.
Dee, you've said that you've accepted the role of the consultant here, and your client is the lawyer. But once you define what you can do, even at this stage, to assist your lawyer client, do you actually then talk to the client? Do you go off into the boardroom and have a session to give your perspective of how you're broadening the horizons and the perspective of the client? Or are you just giving advice to the lawyer alone?
The definition of client remains the lawyer.
Yes.
Is that your question?
Yes.
Yeah. I love the term managing reality. I just think that's great. Diana and I were talking about this earlier this morning, that if I'm retained and my memo or my letter of understanding captured that first conversation about what her expectations are, and now the scenario has shifted and the goals, because the client's driving the bus, the client meaning her client, it may not be conforming to my understanding of what my role is. So I have to go back to my client, the attorney, and say, can we talk? I need to understand what it is that your client wants you to do, what your client's expecting of me, and I have to decide whether or not I can do that, staying in an ethical way. And it may be that I write another memo of understanding to clarify the next stage. Or it may be I say, I'm not going to do this. In which case, she's never going to hire me again, or she thinks that was a great move. But anyway, I have to stay true to my ethics and decide whether I can make the shift that I'm being asked to do.
And he's walking out of her office saying to himself, this is now becoming an amorphous blob and changing roles request. Preparation of the client, evaluation of the process. Now, you hire a consultant to assist clients in understanding the process and dealing with their feelings about the process as it unfolds, preparing them to better present the various steps of the process. Afraid of psychological tests? Can you help? In what degree? So now that you're into this assessment, it's ongoing, the client says, these are some of the things I need to know. I don't understand this process. My lawyer's preparing me to give testimony, but I don't think that's the same thing that I should be doing before this consultant. I thought the consultant was going to handle educating me on how to talk, dealing with my emotions, because I'm an absolute wreck. I'm all over the place. The anxiety of this is killing me, so I just know I'm not going to say the right thing. And now they're saying I got to come in next week and do a bunch of psychological tests. What are you going to do for me, Rennie?
Well, I'm going to try and calm them down. I would...
As the moderator or as the client? Okay, good.
I would, certainly, as I would refer them to that.
All right, so what you're seeing is that the children probably need a therapist here. The fiancé may have different issues that you will have to deal with, maybe needs a different therapist, and the father might be needing a different therapist. You as a consultant, are you going to say, we need to bring this emergency wing of the hospital and attach it to your house? How are you going to handle that?
Here's the 919. You call if you get
John,
Yes.
if I may chime in, I'll go out on a limb here. Let's just hypothetically, Diana's client might have a personality disorder. It's rare, but the person has narcissism beyond belief, and money to match. And so my role as consultant is to help Diana learn how to manage this egomaniac. And so that still feels okay to me in terms of trying to get the services and strategizing with her about how to talk to narcissistic folks so you don't inadvertently wound them so they fire her and I'm fired too. So we have a mutual interest in keeping the case managed, and my goal is the psychological best interest of the children. At least at first blush, one of the parents has got a personality disorder.
All right, but the father goes back to Diana, the lawyer, and says, I can't believe this. You hired this consultant to be as part of our team. He's reframed me, I'll put it that way, to be able to talk to these doctors doing the evaluation, and the evaluation's going badly. The evaluation's going horrible. The assessor wouldn't talk to all the collaterals. The assessor wouldn't even read my 80-page summary of what I felt was important for him to know, and was incredibly rude to Mary. So can you bring the consultants back and say, where do I go from here? How about you, Rennie?
I would say, oh, boo-hoo.
Oh, boo-hoo.
Yeah. I hope she got the full retainer by the time she said that. Okay.
Well, let's see. Wouldn't we decide? Let me see what the issues were again, because they aren't saying anything else.
You want to go back one?
Yeah.
Okay.
Go back to the last
Yeah,
one.
it's
Yep.
called keep your consultant
It's
focused.
going badly.
Won't read. Okay. And
So in essence, what you're doing is you're having a meeting with the client, and you're taking the cool your jets strategy and putting this into perspective that all is not lost.
yes, that's right.
All right.
That's exactly
But then the next move all looks like it's being lost. The disclosure meeting with the evaluator, Henry and Mary ask the lawyer if he can come along, because the evaluator wants a disclosure meeting, wants to share his findings with the lawyers and their clients. And what would everyone do? They have mystery. What's going to happen here? He's not going to give the end results, but just sharing all of the major findings. Lawyer's afraid if I attend something like that, I'm going to be a witness. And the client says, well, how about the consultant? Can the consultant come along and help me through this type of meeting? Diana, you ever encountered this?
Not with a consultant. In my jurisdiction, we actually do have disclosure meetings where the attorneys participate. And that really can create an issue if the process of that evaluator is that I use everything, including the disclosure meeting, in ultimately deciding what I'm going to testify if I have to testify. If they say whatever happens in that disclosure meeting is confidential because it's purely for the purpose of information, it's less of an issue for the attorney. But as far as I'm concerned, my consultant is my right arm. My consultant is an extension of me. If my consultant's there, it's the same as if I'm there. And more so, if my consultant is there, my consultant's work product privilege may be gone because I've now disclosed the existence of my consultant. I mean, it isn't as if anybody else is invited to these meetings. If you just wanted to bring phone a friend or bring someone else, they wouldn't be allowed. So there would have to be a purpose, and that purpose would be disclosed. That disclosure then creates the precariousness of whether that person is now no longer privileged.
All right, consultant, what would you do if the lawyer calls you up and said that the evaluation came down, the evaluation is not good for the clients, but the evaluator's saying, you know what, I think I won't issue my report, won't file it with the court, but there might be a way of me helping the parties settle at this point. And the lawyer says to the consultant, should I get involved in that? Rennie?
I'm not sure I understand the question. The evaluator is proposing that the evaluator assist the parties settling?
Yes.
I see. And should the consultant be involved?
No, the consultant is being asked by the client, should I even go to that route? Should I go to that meeting?
Well, again, NRD and outline what they're basing.
Yeah, but I think this evaluator is going further and saying, you know what, you might have not to go to the nth degree. I might offer myself as a facilitator of settlement here, knowing what I know.
Well, that evaluator is mixing their roles.
So you'd say no.
I would say no.
Would anybody?
Would anybody say yeah?
Yeah. Would anybody go into that type of meeting?
Well, I would certainly say to my client, the attorney, assuming that I've been allowed to read the evaluation.
Yes.
That would be important. So what has the evaluator said about her client? And did the narcissism get confirmed? You know, let's say that happened. I could make some predictions possibly to my client about what's going to happen in that meeting. Possible. Behavioral. I certainly wouldn't go. I don't want to go. I think that's a bad move. I would refuse to go.
All right, but now you didn't go to the meeting, but then the lawyer's given you a copy of the report, and you've read that report, and you said, oh, this is awful. And the lawyer said, well, can you do a critique and file a report and testify for us?
No, I've already said in my letter of understanding I'm not going to testify. So,
Well, yeah, but we've just shut that retainer down. We want to retain you for something else now, an assessment.
we have to have another meeting.
And a retainer amount being paid.
And the retainer amount is rediscussed, and the objectives are rediscussed.
But you've been involved in...
I'm not going to testify. No matter where we go, it's not going to result in my testifying.
So do all of you feel that you understand the need for this, but the consultant you've had throughout is not the person you can use?
That's correct.
Yeah.
And the attorney's temptation is going to be to use that person for that purpose. And depending on the community in which you practice and how small or insular, it could be a significant temptation, because who knows this case better than that consultant? Who, we don't have to pay to re-educate somebody about all the issues where the consultant's been on board since day one. However, that completely breaches the role boundaries, and I don't want to put a consultant in that position.
All right, I'm going to put one last question because it involves potential money and lawsuits against all of us here. So it's how do the attorney and the child custody consultant address and resolve the liability insurance coverage issues resulting from their expanded exposure created by this attorney hiring the consultant and entering into this legal contract? Anybody got a problem with that? Or do you have extended coverage? Do you put that on your rider? Okay, I'll read it again. How do the attorney and child custody consultant address and resolve the liability insurance coverage that you would project because of this expanded role as a consultant to the lawyer? Any difficulties?
None. Here, I checked with my carrier.
Yes?
When I first started doing this work to make sure that what I was doing in my role as a consultant would be covered, and I am covered.
And like HMOs, do they have a list of lawyers that will only allow you to work with?
From an attorney perspective, it's quite the opposite. I think that I'm potentially committing malpractice if I'm not using the expertise of someone who knows something about an area that I potentially am going to either advise a client about or have to try a case about. So I think having the consultant actually reduces my exposure for malpractice.
Thank you. All right, ladies and gentlemen, what we've done is, I hope, over the last few days, I hope that we have brought out some cogent points that made you reflect on the processes that you use and that motivate you to challenge them as we go along at each step. Because we need to create innovative systems to be able to deal with the complications that we do. There are too many people that we are serving in the administration of justice that we can't serve properly by not choosing the right tool. I think that from what I've heard in the feedback, everyone is willing to now look at all the process that we use because we want the effective and efficient use of the mental health professionals within our court system, especially when we're dealing with issues of custody and access of children. What we do is too important. So continue this challenge, continue this motivation, and we'll see you in New Orleans. Thank you.